So let's take a look at this Supreme Court case, Barnes v. Felix. Barnes v. Felix et al. 2025. And so here's the Supreme Court decision, and then it explains the background, and then let's take a look at the holding. The holding is interesting. So the Fifth Circuit had said that they only check the moment that the fatal shots were fired. This has to do with excessive force, which falls under the Fourth Amendment of police officers. And so the police officer had jumped on the door sill of the car, and then he had said that the car was to drive forward. He felt threatened and then fired his gun. We're going to take a look at the video here in a second, but just to make sure that we understand the holding, the Fifth Circuit, they had said they used a moment of threat rule, the moment of threat. And what they said was that they were duty bound to not only look at the perspective of the officer, but just the moment that the threat had presented itself. So they're going to ignore everything that had happened beforehand. They're going to ignore not only the 1 minute, 2 minutes, days, weeks prior, but they're even going to ignore the police officer jumping on the door sill. The police officer jumps on the door sill, and it almost looks like he pulled out his gun and was shooting as he jumped on the door sill. So we'll take a look at that. But the holding is this: when you consider excessive force under the Fourth Amendment for a police officer, you don't just look at the moment of threat, but you look at the entire case. You look at the totality of circumstances surrounding the murder, the shooting. So here, let's take a look at the video. Here's a picture of when the guy jumps in the car and shoots him. So that gives you just a still. So that's what we're going to see in a minute. And then here is the picture of the two individuals. On the left is Roberto Felix Jr. He's the police officer who jumped onto the door sill and shot and killed the guy on the right, Ashton Barnes. And the reason why he was pulled over was for suspected toll violations. When they asked if he had a driver's license, he said that he didn't. When they asked whose car it was, he said it was his sister's car. It was a rental car in his sister's name. So he was pulled over for toll violations. Toll violations. He passed a couple tolls. He didn't throw his 50 cents into the meter. That was the entire reason for why this Toyota Corolla is going to be pulled over. So now let's take a look at the video. So we're just driving along on the interstate. A police officer's use of deadly force violates the Fourth Amendment when it is not objectively reasonable. That comes from Graham v. Connor. Graham v. Connor, 1989. The inquiry into the reasonableness we have held SCOTUS requires assessing the totality of the circumstances. That comes from Graham v. Connor. And they were quoting Tennessee v. Garner, 1985. So the question is the moment of threat rule, is it enough? Is it enough to just assess the moment of threat? And that's it. Is that it? Okay, so we saw the police officer essentially hurry up, get behind the Corolla. As soon as he turns on his lights, the guy pulls over, like immediately. And this is dangerous because he just pulled him over in the fast lane. And he just pulled over in the fast lane. So you're going to have all these fast cars passing on the right-hand side, and you're going to have a bunch of fast cars passing on the left-hand side as well. So let's take a listen to some of this. The guy is going to tell him to stop digging through his stuff, and he's also going to say he smells marijuana. And it looks like, what is that, Texas license plate?
violation. When did you put the vehicle? About a week ago? I'm sorry, I couldn't hear you.
It's actually rented in my girlfriend's name. I'm on the way to get it watched and turn it back in.
Okay.
So we can hear the audio pretty crystal clear. He had said that it was rented in his girlfriend's name. He said it was a rental car. And then the police officer says, I understand that. Do you understand it? Because it feels like you didn't understand it at first. Let's keep listening.
What's your name? Okay. You have your driver's license? Anything this vehicle I need to know about? Okay. I'll go digging around. I smell marijuana. Is there any marijuana in the vehicle? Don't dig around. Don't dig around. Don't dig around. Okay. Do you have anything, any identification on you? Okay. Sure, go ahead and pop the trunk for me. Okay. Go ahead and put that paper off the top for me.
So you see the guy's got his hand on his gun. He was yelling at him to stop digging around, stop digging around. Then he also says, I smell marijuana. The reason that that's secondary, right? The reason he stopped was toll violations. And we don't even know if this Ashty and Barnes is the person that's running through the tolls. Let's presume that it is a rental car in his sister's name. So that means his sister could have ran some tolls. It's a rental car, so that means there's a number of people that could have rented that car and broke a bunch of tolls. So let's keep on listening. He said something about the information, the registration was in the trunk, and then the guy says, can you pop the trunk for me? And he just popped the trunk. So
Go and check out for me. Don't fucking move! Don't fucking move! Watch out, go through shot fire! Shot fire! Shot fire! Shot fire! I think that's HFD! HFD there!
So that's the video, and that pretty much shows, the extent of the interaction. We can go back a few seconds and just take a look at the climactic moment, because they're saying at the moment of threat is when he jumps on the door sill, or actually after he jumps on the door sill. So they said the moment of threat had nothing to do with what the police officer did. It had nothing to do with the severity of what prompted the stop to begin with. The moment of threat was after he had jumped on the door sill. The guy's driving away, so therefore he felt like his life was being threatened. His life was being threatened and other people's life was being threatened. The Supreme Court has rejected the moment of threat rule by the Fifth Circuit. Here they say that SCOTUS rejects the moment of threat rule because it improperly narrows the requisite Fourth Amendment analysis to assess whether an officer acted reasonably in using force. A court must consider all of the relevant circumstances, including facts and events, leading up to the climactic moment. So you got to look at all of the entire, ordeal. You got to look at all the facts, every bit of it, not just after he had jumped on the door sill. I mean, why is he even standing on the door sill to begin with? In a way, he had kind of instigated the more violent thing because he jumped on the door sill, and I guess he was trying to stop the car. I'm going to stop this car by jumping on the door sill. And then it's also for toll violations. Toll violations. So let's take a look at this again. We even hear the gunshots. And so basically it just a few seconds, right? Just a few seconds. They even say the seconds. It was like 5 seconds. He jumps on the door sill. He's hanging on the car for 5 seconds, and then within 2 seconds, he fires the fatal shots. But this whole stop, I mean, we're already 3 minutes into the video, and I don't even know how long the stop had taken. We can sort of take a look at when they were pulled the car over. So the car is pulled over there at 1 minute. It's, you know, it was about 2 minutes. So there's been about 2 minutes of an interaction. And I understand that it's a rental car. How would you understand that it's a rental car? You didn't understand that. You didn't even know the damn information. And so the guy is going to jump on the door sill. This is the Supreme Court, the conservative Supreme Court. The reason why this case is significant, because usually the cops could just run hog wild, right? The cops could do whatever the hell they please. If they want to jump on a door sill, if they just want to shoot people, if they just want to say they had smelled marijuana and that was a good enough reason, they could just make it up. They could just say whatever the hell they want to say, and then you look at their perspective, and even if they had no information and they got the entire situation wrong, well, from their perception, you know, they had to, you know, shoot the kid because the kid had a candy bar that could have been laced with cocaine, and it was a big, you know, cartel kind of thing. Let's take a look.
Don't fucking move! Don't fucking move! Watch out, 14, shot fired! Shot fired!
Now he's still poised with the gun pointed at the guy who's been fatally shot. You know, shots fired, shots fired. So now you're going to have 20 squad cars thinking that there's, you know, an active shooter. And then I'm also looking at this interstate where you have just a bunch of people driving one way, a bunch of people driving the other way. There was a murder that just happened on the interstate. And you have pretty much a bunch of witnesses who saw the stop. And I'm not for sure. I just, you know, almost feel like you would want a cop watch. You would want Black Panthers. You would want somebody to just, you know, as a police force, just hire your own cop watch in order to make sure that the cop doesn't use excessive force and do too much. Now, he still might be ruled that it was okay and justified, but that the way that they were arguing about it in both the appeals court, the Fifth Circuit Appeals, and the district court was that they were duty-bound. They were duty-bound to just consider the moment of threat. And so he's up on the door sill. Since he's up on the door sill, the car is moving. Well, he could have been flung off. He could have had serious bodily injury. You know, he could have fallen into the concrete. There could have been some kind of death. You know, maybe there was some sort of gun that the guy could have, you know, had. He could have kept driving real fast and then would have pushed him out. I mean, if you just make up a bunch of crap, right, the threat is incredible. This reminds me of Samantha Ramsey in Boone County. The guy jumps onto the hood of the car. He jumps onto the hood of the car and shoots her in the heart. And why did he jump on the hood of the car? Because he goes to a field party and he's trying to stop everybody from leaving, and Samantha Ramsey had got into her car and he said stop, and she didn't stop and she kept driving. So he runs over to the car, jumps on top of the car, points the gun at her and shoots her and kills her. Shoots her in the heart. And then that's going to be $1 million lawsuit. The estate of Samantha Ramsey is going to win that court case. And then you have Kavanaugh. Kavanaugh, there was a concurrence. So even though this case is being said to curb excessive violence and that it's actually against the police, they're going to limit the amount of excessive force that the police can do. And it does, because they're throwing away just the moment of force, right? What is it? The moment of threat rule. The moment of threat rule. So you can't just look at just the moment of threat. You got to look at the entire totality of all the circumstances of what led to this shooting. So that limits it narrowly, but you had Kavanaugh had a concurrence along with Alito and Thomas and somebody else. I want to say maybe Barrett. But the Kavanaugh concurrence, he mentioned Tim McVeigh and Ted Bundy. He was just talking about how dangerous a traffic stop could be. Most of the police murders have happened during a traffic stop. And it happens, all the time. They listed 2 cases, and they said that the list goes on and on. They also mentioned Tim McVeigh and Ted Bundy. Tim McVeigh was pulled over because he was missing a license plate. And then they found out that, he blew up the Oklahoma City building. And then Ted Bundy was in a stolen car. And then when they pulled him over, he swept the officer's legs, and then he's trying to get the gun away from the officer. And then eventually the officer is going to arrest Ted Bundy, the, infamous serial killer. This decision was decided May 15th, 2025, so it just was decided 16 days ago. Kavanaugh also floats the ideas of what could be in the car. There could be anything in the car. If somebody pulls over and then takes off, you don't know what's happening. You don't know what's happening. It couldn't be that the police state is going to come up with some trumped up bullshit charges. The oppressor isn't going to be mad that you disrespected his authority. First you respected it, then you disrespected it. He's saying that there could be illegal drugs, there could be an illegal gun, maybe there's an illegal person, maybe it's an immigrant who's not even supposed to be in the country. Maybe there's a warrant for murder or rape. Maybe there's an abducted child. Maybe there's an abducted child. And maybe the person could try to use the car as a weapon, which Kavanaugh had pointed out had happened in New Orleans. They also point to a different case, Plumhoff v. Rickard, 2014. This goes back to the majority opinion. It was a unanimous opinion by Kagan. A unanimous opinion by Kagan. Kagan is the one that's going to write this. So good for Kagan. She gets to write a majority opinion. But in Plumhoff v. Rickard, 2014, just to point out that the moment of threat isn't a good rule for the other direction, the estate had sued the police because they said that the police chase was over. And since the police chase was over, the police didn't have a right to shoot the driver of the car. Well, it was a 5-minute police chase that was 100 miles per hour. So a 5-minute dangerous police chase where the guy's driving, 6 police cars are chasing him, and he's driving up to 100 miles per hour. And then at the end of the chase, he wrecks into a police car, and then as he's wrecked, and they said that the car was stopped, and so he's going to get shot for no reason. Even the moment of threat rule actually says the guy was spinning his wheels. So even though he had wrecked his car, and it looked like he couldn't move anymore because it was totaled, he was still trying to punch on the gas and still trying to give what little bit of energy that the car had. So perhaps you could look at the moment of threat. The police chase was over. He did, spin his wheels a little bit, but the car wasn't moving anywhere. Since there was no threat, there was no danger, what's the problem? Why did you shoot and murder him? Well, you would have to ignore that there was a dangerous 5-minute police chase where they were driving 100 miles per hour and there were 6 police officers who was chasing them. You'd have to ignore all of that and just look at the moment of threat. And was there a moment of threat? It could be argued there was. It could also be argued that it wasn't. So the moment of threat rule can go both ways. And I think that's a pretty good summarization of this case that was just handed down by the Supreme Court, called Barnes v. Felix et al. 2025. Barnes v. Felix.